No, sir.
What?
You are in custody right now. If you leave the courtroom, it's a felony escape.
That's a felony to put me in custody because you have no authority or jurisdiction or standing.
Today we're looking at one of the most intense and emotionally charged court hearings we've seen in quite some time. This case involves a self-identified sovereign citizen who appears before the court after failing to comply with a warrant that required him to surrender himself. From the very beginning, it's clear this hearing is going to be anything but ordinary. The defendant's arguments quickly take an unusual turn as he begins making claims that challenge not only the court's authority but even his own legal status. These statements immediately raise serious concerns and set the tone for a tense and unpredictable exchange. Situations like this highlight how complex and difficult sovereign citizen cases can become once they enter a real courtroom setting. I also want to mention that while the video quality isn't the best, the content of this hearing more than makes up for it. The exchange itself is compelling, revealing, and offers a striking example of how courts respond when defendants reject basic legal principles. It's one of those cases that keeps your attention from start to finish because of how far outside the norm the arguments become as you watch. Pay close attention to how the judge manages the situation and how the defendant responds when faced with firm legal boundaries. I'd really like to hear your thoughts. What do you think of the arguments being made here, and how do you feel the court handled them?
Okay, so you failed to appear for court multiple times in this case.
Your Honor, just for the record, the named defendant is actual property, a registered trade name.
Oh, here we go.
And the case has also been certified as a fraud. I have court-certified documents to prove that. That should be on the record, and that's the reason why it was certified to be a fraud, because the plaintiff is a foreign-owned private corporation, of which I have no contract with, and neither does the registered trade name. And the registered trade name has been used without authorization and permission, and there's an act of identity theft, and that's probably one of the reasons also why the state has acquiesced that both cases are a fraud. Let me add one more piece of information. I am a foreign sovereign with respect to the privately owned foreign corporation known as the state of Washington.
Yes, on the 303 matter, Mr. Haywood was sentenced to serve 4 days in jail. He failed to report to the jail on June 29, 2020. June 29, 2023, and we're asking him to be taken into custody to serve that time.
No objection, Your Honor. I actually contacted the jail to make special arrangements to deliver the defendant with the special arrangements to not damage the paper, and the jail refused. So I attempted to deliver the defendant, and objection, the state has no standing as they are representing a privately owned foreign corporation, and the prosecutor is not licensed to practice law in this country.
So here's what the defendant is claiming happened. According to him, he went to the jail carrying a written document with his name on it and believed that turning in this paper was the same as surrendering himself for the warrant. In his mind, presenting that document somehow fulfilled his legal obligation, as if the process worked on his own terms rather than the court's. Of course, that's not how the system operates. A warrant requires a person to physically submit themselves into custody, not hand over paperwork and walk away. The jail staff did exactly what they were supposed to do by rejecting the claim, because a document alone doesn't satisfy a lawful arrest or surrender. The explanation he's offering shows a serious misunderstanding of how warrants in custody actually work. What makes the situation difficult to interpret is whether he truly believes this reasoning, or if he's exaggerating his position to create confusion and delay the process. It's hard to tell if this is a genuine lack of understanding or a deliberate attempt to perform for the courtroom. Either way, the argument doesn't hold up under legal scrutiny. Even among sovereign citizen cases, which often include unconventional and legally unsupported claims, this one stands out. The logic being presented feels disconnected from reality, and the court is clearly struggling to move forward while addressing these assertions. Each explanation only raises more questions rather than clarifying anything. Let me know what you think so far. Do you believe he genuinely thought this would work, or does it seem like he's intentionally complicating the situation? Drop your thoughts in the comments, and let's jump back into the hearing to see how the judge responds next.
Okay, so I think it's the 303 that he was convicted and ordered to do jail, and you believe that he didn't comply with jail, because there's a docket entry that said defendant complied with jail. Maybe that was an error.
That was probably my attempt to deliver the defendant to the jail, but they refused. And just to clarify, the defendant only exists on paper, just as the plaintiff only exists on paper. The jail refused the paper, and here we are today. And the state still hasn't proven standing yet, by the way, as well.
So, Mr. Haywood, it doesn't look like you did the sentence on the 303 matter, and so I am going to quash the warrant. However, I am going to have you serve that time.
Okay, well, I'll deliver the paperwork to the jail. That's fine. I tried to once before, but they refused it. And just to clarify, I'm not the defendant. There is nothing on there, nor is there any testimony from anybody as first-hand witnesses under penalty of perjury that I am the defendant. And I've uploaded plenty of documentation to prove I'm not the actual defendant. That is a registered trade name, matter of public record, and registered with the state. So if you want me to serve some jail time, then we're going to need to change who the defendant is, because I'm not the defendant.
All right, so can you upload a new commitment?
Yes, Your Honor.
And the reason they couldn't put my name on there as a defendant is because I'm a foreign sovereign with respect to the corporate entity known as the state of Washington, of which I have no contract with.
Well, you had your day in court on the 303 matter. You had a trial. You represented yourself or the defendant, whichever way you want to say it, but you represented the defendant yourself, and you were convicted, and you were ordered to serve 4 days in jail. You didn't do that.
The defendant was ordered to serve 4 days in jail, and I attempted to deliver the defendant to the jail, but the jail refused.
Okay, well, I'm going to make sure that they don't, because I've done a new commitment for you today so that they won't refuse for the defendant to serve that time. You're going to serve those 4 days, and then you'll be released, and nothing more will happen on that 303 case. You'll be done. And then this case will be heard August 24th at 10:30 in the morning. If you change your mind about representing yourself, then you can ask for help if you want it. If you don't want help, we don't have to have it. So we'll see you in August. I'm going to have you take a seat right over there.
I won't be here for the defendant on August 24th. Would you like me to deliver the defendant to the jail?
I would like you to sit over there.
Is there any standing
with the defendant
jurisdiction chosen, proven here yet?
Please go take a seat.
Okay, so let the record reflect no jurisdiction has been proven.
At this stage, the situation is becoming increasingly difficult to follow. The defendant's behavior shifts constantly, and his responses seem inconsistent, which only adds to the tension in the courtroom. He repeatedly interrupts the judge, challenges her authority, and speaks as though the rules of the court don't apply to him. It's understandable why some viewers might feel the judge has already shown an extraordinary amount of patience. The moment he claims that he doesn't even identify with his own legal name is especially telling. Statements like that fundamentally disrupt the court's ability to proceed, because the legal system relies on clear identification and accountability. When someone refuses to acknowledge even the most basic legal facts, it puts the entire hearing at risk of becoming unmanageable. Many judges will consider this type of conduct grounds for immediate corrective action, including a warning or even contempt proceedings. Courts are required to maintain order, and repeated interruptions or refusals to recognize jurisdiction can cross a very serious line. At the same time, judges sometimes allow these arguments to play out briefly, giving the defendant every possible opportunity to correct course before consequences are imposed. This raises an important question about courtroom strategy. Is it better for a judge to step in quickly and shut this behavior down, or to allow the defendant enough room to demonstrate, on the record, that these arguments have no legal basis? In this case, the judge appears to be choosing restraint, possibly to avoid giving the defendant grounds to claim unfair treatment later. What do you think? Should the judge have taken stronger action sooner? Or is this one of those hearings where patience ultimately serves the court better? Share your thoughts in the comments, and let's dive back into the hearing to see how the situation continues to unfold.
And neither has the identity of the defendant definitively been established.
Okay, please go take a seat. Sonia Sesko, customer 231024002. Mr. Haywood, sit down.
Am I obligated to follow these rules?
You are going to sit down right now.
Do you have any jurisdiction? I don't believe you have any jurisdiction's been proven yet.
Please sit down.
Are you threatening me with violence?
I'm asking you to sit down.
You don't have authority over the defendant. You have no authority.
What do you think you're doing?
Mr. Haywood?
You're escaping?
I got things to do.
No, sir.
What?
You are in custody right now. If you leave the courtroom, it's a felony escape.
That's a felony to put me in custody because you have no authority or jurisdiction or standing. You got some proof of
Okay,
that?
well, we are all being recorded, so if you leave this courtroom, it'll be a felony escape charge. Your choice.
Okay, well then, I guess in the best interest of peace, in regards to your violence, I will go ahead and relax for a minute, but let's get with it. I got things to do. Got it?
What was that just thrown?
Car keys.
Do you know that person?
Yeah, they're my voice.
Okay. All right. So thank you. Mr. Haywood has been very disruptive. He tried to leave the courtroom once he was placed in custody. So just FYI, be careful with him.
So, give me a break. Can I just see just need to see it, thank you. Can I see who's being put into custody, please? I just need to see the name. I just need to see the name of the person. Okay, that's not me, that's the problem here.
Christopher Sanborn's matter. We're here today on
That's not me.
issue.
The name is saying, but that's my registered trade name. I got all that documentation right here.
Okay, good. We're going to take care of it.
Okay. Yeah. Well, this is the defendant technically.
If you want that, I can go with you, put everything private.
Hold on 1 second. Well, that's taken care of.
We can think that we can get the right name.
Did she file a notice of appearance?
I will make sure that she does, Your Honor.
Yeah, sorry, I haven't had enough coffee yet today. So yeah, no, you've got Ms. Bradshaw, so that's fine. You don't need to do those forms. But she does need to file a notice.
At this point, it's clear the situation has reached its limit. The court can no longer allow the hearing to continue in circles, and taking the defendant into custody becomes a necessary step to restore order. His repeated refusal to cooperate and his reliance on sovereign citizen arguments have left the judge with very few options. The defendant appears fully committed to a belief system that claims laws don't apply to him if he simply rejects them. This mindset shows up often in sovereign citizen cases, especially among individuals who rely heavily on online forums and misleading legal theories. They genuinely believe that declaring themselves outside the system will somehow override established law. But that has never worked in an actual courtroom. And no matter how firmly someone insists they are not subject to the law, the legal system does not operate on personal declarations. Courts rely on statutes, precedent, and procedure, not individual belief. Every attempt to deny jurisdiction or reject authority only adds more complications and often results in harsher outcomes than the original issue ever would have caused. What makes these cases especially frustrating is that many of them start with relatively minor matters. In some situations, the issue could have been resolved with a fine, compliance, or legal representation. Instead, sovereign citizen arguments escalate the situation, turning small problems into serious legal consequences. In the end, the pattern is always the same. The more a defendant resists responsibility, the fewer options the court has. The law doesn't respond to slogans, theories, or improvised rules. It responds to actions. Refusing to engage properly with the process doesn't expose a loophole. It accelerates enforcement. Now I want to hear your thoughts. Do you think this defendant truly believed these arguments would work, or was he intentionally leaning into the sovereign citizen role? Share your take in the comments below.